Hello, I'm Professor Kozlowski, and welcome to my webpage at George Mason University. You can see a number of courses that I teach, most of which are web-based online televideo courses. And the materials in these courses, for the most part, revolve around monthly law review articles that I've written for the Parks and Recreation magazine, which is the official publication of the National Recreation Park Association. And there's a link to an archive of these articles on my webpage. This column began in January of 1982 to the present, and today we'll be looking at another one of these articles and case reports to give you a little better understanding of legal topics and legal principles in various aspects of parks and recreation. Today's article, we'll be going back to an article that was published in February of 2012, and the title is Park Occupation Protests, Is it Protected Speech or Camping? And this particular article was prompted by the Occupy Wall Street movement that spread across the country starting in the summer of 2012 and into the fall of 2012. And these Occupy events in the various cities oftentimes took place in public parks and places, these 24/7 occupations. And they took the form of establishing permanent campsites for the protesters. And the question was whether there was a First Amendment free speech right to do so. And this issue had been effectively addressed in a 1984 decision of the United States Supreme Court in the case of Clark versus Community for Creative Nonviolence. And in that case, there was a symbolic tent structures put up in the National Mall in order to publicize the plight of the homeless nationally and in the District of Columbia in particular. And there the Supreme Court found that when camping was mere conduct, it wouldn't be protected by the First Amendment. But where the campsite itself was established to illustrate, reinforce the message, it would be protected symbolic speech. So the regulations at issue in that case, the Park Service regulations, prohibited camping on the National Mall, and the Supreme Court found that while the Park Service could prohibit effective habitation on the mall, living on the mall 24/7, the Park Service did allow the homeless group CCNV to construct a symbolic tent city. And that was part of the message, and that would be protected by the First Amendment, as we'll see, subject to reasonable time, place, manner restrictions. Similarly, more recent case involving the Occupy movement illustrates a lot of these pretty basic constitutional law principles. A number of cases have been reported surrounding the Occupy movement, and many of them are similar to one of the first cases that, best of my knowledge, was reported. And this was the case we'll be looking at today. And that was Occupy Fort Myers versus City of Fort Myers, federal district court case issued by the Middle District of Florida, and the opinion was issued on November 15th of 2011. And here the Occupy Fort Myers folks were looking for an emergency motion, a preliminary injunction to stop the city of Fort Myers from issuing citations for illegal camping in the park, and they claimed that this infringed on their First Amendment rights, as we'll see. Now, Occupy Fort Myers, as many of these Occupy movements, sort of a loosely affiliated group of individuals, not incorporated, sort of a spontaneous gathering of folks, which in some instances makes it more difficult to identify who or whether they should be required to have a park permit for their particular spontaneous gathering, if you will. Not so much an issue here, but certainly an issue that comes up. Now, the core purpose of Occupy Fort Myers was stated to bring awareness to the concerns about the U.S. political process, economic policy, through symbolic, around-the-clock peaceful protests. These were referred to as occupations. Clearly, there's a political message here that, as we'll see, will be protected by the First Amendment. And this camping has a symbolic element, but to what extent is it protected symbolic speech or merely unprotected conduct, camping, if you will, living in a park? And in any event, we'll see that it's still subject to reasonable time, place, and manner governmental regulation. So in this particular instance, the planned symbolic occupation was of Centennial Park in Fort Myers, and the police department had advised Occupy group that they should contact the city's recreation division to request a permit for overnight occupation. As we'll see, the parks are closed after 10:30, so that if you're in the park after that time, you'd be breaking the law unless you had a permit to do so. Now, even though it was violating the ordinances, the police weren't necessarily required. They have prosecutorial discretion. At first, they weren't issuing citations. They allowed occupation of the park for an evening without a permit, and they were provided with a special events pamphlet describing how to obtain a permit so they could occupy the park overnight. But the sticking point for the group, they were informed by the city that their permit application would be reviewed, but they had to obtain a $1 million liability insurance policy and bring that insurance certificate to the city. And for the Occupy Fort Myers group, this would be a deal breaker. Later on, they informed the city that they could not comply with this insurance requirement because they had no funds to pay for it, even if such insurance was available. And generally, where there's a fee attached to a permit where it's involving First Amendment activity, it has to be fairly minimal. Furthermore, there has to be what's called indigence or pauper's waiver. In other words, where these fees would be waived in order to allow groups, many of which do not have any economic resources, in order to exercise their First Amendment rights. So is this insurance requirement, does it effectively muzzle or suppress First Amendment rights of the Occupy group, that requirement? Furthermore, as we'll see, they were told without a permit, they would be prohibited from camping in the park because the existing ordinance is fairly general in many instances. Parks are open from 6 a.m. till 10:30 p.m. So if you remain in the park after 10:30, you're violating the ordinance, and as we'll see, that's what happened later. While this Occupy group was continuing to try to negotiate for a permit either to appeal the insurance requirement or get a waiver, which they may have been entitled to, as mentioned under general principles involving park permits and First Amendment activity. However, on the evening of October 20th, 2011, after that 10:30 closing time, the Fort Myers Police Department began issuing citations to the Occupy individuals for violating the city ordinances. And the police chief stated that 73 such citations had been issued. And the Occupy Fort Myers folks, that's the controversy here, maintain that the citations were issued based upon unconstitutional ordinances, that they're effectively being punished for their involvement in symbolic First Amendment protected speech. So an issue is, was this indeed symbolic speech protected by the First Amendment, or was it unprotected mere conduct, simply camping without any sort of attached symbolic message, political or otherwise? And furthermore, if it is protected symbolic speech, to what extent could it be regulated? Were the governmental regulations here reasonable time, place, and manner restrictions? So the first point is that the First Amendment rights are not absolute. They, again, as we'll see, are subject to governmental restrictions in the form of reasonable time, place, manner restrictions. So just to start out, people cite the First Amendment, but not too many people can quote it. But to give you the flavor, the chord here quotes the First Amendment: "The Congress shall make no law abridging the freedom of speech or the right of the people peaceably to assemble and to petition the government for a redress of grievances." So this refers to the U.S. Congress. And here the challenge is to the city of Fort Myers. But the Bill of Rights in general and the First Amendment in particular apply to the states and localities under the 14th Amendment. So municipal ordinances for Fort Myers here would be subject to First Amendment principles, that these ordinances constitute state action because the Constitution, the Bill of Rights, protects you against your government, whether it's federal, state, or local. So there has to be an element of state action, which in some cases that may be an issue, but clearly it's not the case here because we're dealing with the Fort Myers, city of Fort Myers, their police department, parks and rec department, and alike. So here there was no dispute that the First Amendment would apply to these city of Fort Myers ordinances. Once again, though, First Amendment protection is not absolute, and that a city government need not permit all forms of speech on its property that it owns and controls. Even though, as we'll see, parks form the quintessential public forum in which to exercise your First Amendment rights, like the traditional town commons, where you can jump up on your soapbox and air your grievances against your own government or any issues of social concern. So here, having found the First Amendment applies to the city's conduct, the issue before the court in this case is whether the First Amendment would protect the specific speech at issue. These park occupations to protest economic conditions, and whether the governmental restrictions on such speech, assuming it is protected speech, were those governmental restrictions valid under the First Amendment. The court cites that one of the primary purposes of the First Amendment is to protect and actually promote free exchange of ideas, free discussion of governmental affairs, and that's a basic premise of our democracy. And noting that political speech is sort of the highest rung, the epitome of First Amendment protection. And that would occupy, as the court says, the highest rung of First Amendment values. And clearly here, the Occupy protests are political speech mixed in with this occupying activity, which involves some sort of camping that, as we'll see, may be in violation of park closure laws or anti-camping ordinances, which are fairly typical in public parks. But how are these otherwise legitimate governmental interests and ordinances looked upon when they're applied in a First Amendment context involving symbolic speech, and may be viewed by some as a mere pretext in order to restrain people in their free exercise of their First Amendment rights. So in terms of free speech, it's a fairly broad definition. It's a matter of public concern relating to any political, social, other concern of the community, subject of legitimate news interest, and value concern to the public. And here, clearly, court noted there was no dispute among the groups that much of the conduct by Occupy Fort Myers and its participants fell within the protection of the First Amendment. And the city acknowledged that such things beyond pure speech that would be conduct containing a message, be symbolic speech protected by the First Amendment, would be such activities including rallies, marches, distribution of literature, displaying signs and posters, and engaging in conversations on topics of public concern, and that these occupations were for the purpose of illustrating matters of public concern and therefore well within the protection of the First Amendment. And what the court, the issue here, found more problematic, however, and was addressed by the U.S. Supreme Court in '84 in that CCNV case involving camping on the National Mall, was Occupy Fort Myers claimed to First Amendment protection for what was essentially sleeping or camping activities. Once again, the First Amendment protects speech, but there's no First Amendment protection for mere conduct. So where would the line be drawn here? And as if, and I would suspect, Occupy Fort Myers, some folks involved would have reviewed the Supreme Court decision from '84 and tried to fall in the line where their activity would be considered symbolic speech, not mere camping, which could be prohibited. They described their current conduct in Centennial Park, setting up 10 to 12 tents, 4 or 5 people within the tents 24 hours a day, and remaining participants rotating in and out. So the question is, these people, that 4 or 5 that are there 24 hours a day, in addition to their free speech activities, have they effectively set up residence in the park? And that type of conduct, certainly in the Supreme Court case involving the National Mall, People were prohibited from setting up house in the camping in the mall 24 hours a day. So it's kind of a mixed bag here. Further described that participants would eat food brought to them that they didn't cook in the location, but that wouldn't not prohibit finding that people are effectively living there in violation of what most Parks and Rec departments have, an anti-camping ordinance for public parks. And OFM's description appeared to be inherently fluid. There are no fixed number of people, fixed duration of the occupations have ever been specified. Now, the city maintained that their activity was mere conduct rather than speech. And the point being that if it indeed is mere conduct, it's not protected by the First Amendment. Occupy Fort Myers, however, countered that their occupation was not just camping out, that there was a message to be had that was protected by the First Amendment, that this indeed was symbolic expression that should be protected by the First Amendment. So the court has to analyze the facts of this case in terms of, is it indeed symbolic conduct? So the Federal District Court acknowledged, in general point, is that First Amendment protects not only pure speech, but also symbolic speech. And how does symbolic speech differ from unprotected conduct or pure political speech? It delivers a message by conduct that is intended to be communicative and in that context would reasonably understood by the viewer to be communicative. So I suspect that if you were walking by Centennial Park in Fort Myers at the time, you wouldn't necessarily think that this group of people were simply camping out. That clearly there was a message to be had and communicated by the Occupy movement in general and Occupy Fort Myers in particular. So while other courts have recognized, and the Supreme Court certainly acknowledged in the CCNV case in 1984, just sleeping out of doors is not a fundamental right per se in and of itself, because the reasonable observer wouldn't not necessarily understand if I'm sleeping in a park that there's some sort of message I'm trying to communicate. They may just think I'm camping out or not. So the act of mere sleeping in a public place, absent some sort of symbolism that communicates a message, absent expressive conduct, mere conduct, again, is not constitutionally protected. Court, however, acknowledged, as the Supreme Court did in their 1984 decision involving Community for Creative Nonviolence, that under certain circumstances, sleeping and or camping could be expressive conduct. So the question is, under the facts of this case, was there a message to be had? And the court found that the tenting and sleeping in the park, as described by Occupy Fort Myers, was indeed symbolic conduct which would be protected by the First Amendment. That this 24-hour occupation was intended to send a message. It was intended to be communicative and reasonably understood by the viewer to be communicative. So once again, if I walked by this park at the time, I would see it as a demonstration, not merely people involving in camping activity. And that the conduct, their occupation 24/7, was to express matters of public concern. The 1% and the 99%, the economic disparities that they were trying to bring attention to by their activities, that it involved political, social, or other concerns of the community, and was a subject of general interest and value and concern of the public. So in their minds, that this economic disparity was something to be effectively illustrated and protested, which found its genesis in Occupy Wall Street, that the people in the park were at an economic disadvantage to the financial district, i.e. Wall Street. And it spread to the rest of the country, and here we have the situation in Fort Myers. And they noted that conduct may change over time. Here the argument was made that this unassociated group, that there were a whole variety of messages, kind of a mixed bag, and so if people are protesting all kinds of things, would a whole kaleidoscope of messages, the cacophony of the whole situation, undercut and turn symbolic speech into mere conduct, that the court noted, well, it's changed conduct can be addressed when and if it occurs. The fear being that these people would effectively be squatters and take up residence in the park indefinitely, long after the Occupy message maybe disappeared. Now, as we'll note, public parks are the quintessential public forum for the expression of First Amendment activities. Although subject to reasonable time, place, and manner restrictions, if you have anywhere, you should have a right to make your case on matters of social concern or protest the government, or demonstrate. It should be in public parks and streets. So here we're looking at the validity of the governmental restrictions on this particular Occupy movement, and the court would consider the type of speech and the forum to be regulated. Here we're regulating a park, and to what extent could the government regulate this symbolic camping activity? So just as political speech is the highest rung on the hierarchy of speech to be protected by the First Amendment, public parks are the highest form of public forum for such protected activity and expression. So the court noted that a public park like Centennial Park here was among those venues which have historically been considered public forums, closely associated with the free exercise of expressive activities. Again, the soapbox, the town common, the ultimate one being Lafayette Park right across the street from the White House. The court noted, Supreme Court has found that streets and parks have been immemorially held in trust for the use of public time and have been for purposes of assembly, communicating thoughts between citizens, discussing public questions. And that any regulation of such speech activities on government property that are available for public expression, like public parks, court noted they are subject to the highest judicial scrutiny. The burden's on the government to show that these regulations really are necessary and reasonable time, place, manner restrictions involve, as we'll see, significant governmental interest, and certainly don't go any further than they need to. So that to the extent these regulations will be upheld, regulating a public park used as a public forum for First Amendment activities, any restrictions, governmental restrictions, have to be narrowly drawn and achieve a compelling state interest. So the question is, not made a big deal of it here, but this insurance requirement, is that absolutely necessary? What is the compelling state interest here? Moreover, this issue of the park closure hours and the anti-camping ordinances, as we'll see, are at issue. And as applied to this First Amendment activity, do they go too far and serve as a restraint on free speech? So individuals don't have unfettered, unlimited access to governmental property, including public parks, under the First Amendment. Such conduct, as mentioned, is subject to reasonable time, place, or manner restrictions. Moreover, the court noted that such constitutional restrictions, the ordinances here being challenged, depend largely on whether they are content-based or content-neutral. In other words, they somehow single out the message so that the Occupy people, their message is subject to a lot more restrictions than some other message, like the veterans want to celebrate their service or returning from the war, or some other ethnic group wants to celebrate their heritage. So once you get to start distinguishing groups and treating one group more rigorously, then your restrictions are content-based and much more suspect from a constitutional standpoint. So content-neutral restrictions doesn't matter who the person is or what their message is, all messages are treated alike, and that there's a tight fit, connection, nexus, narrowly tailored between what is the governmental interest, and here the governmental interest is preserving public health, safety, and welfare in terms of the park resource and protecting that resource so it'll be available for everyone. But that doesn't necessarily, it's much easier to maintain a park and keep it nice for everybody if you don't let big crowds occupy it for First Amendment activity. First Amendment's not going to pay second fiddle to keeping the park nice and clean. And also, where there are restrictions, will they leave open ample alternative channels for communication? So would they necessarily need 24/7 occupation of the park, or could they effectively have their demonstration during the park hours, which it's open, 6 a.m. to 10:30? Occupy Fort Myers here, the fact it's an occupation, part of their shtick, their message, symbolic speech, if you will, involves a 24/7 event, not during regular business hours. So in terms of content neutral, as I mentioned, the ordinance will be looked at whether it distinguishes between good speech, bad speech, good groups, bad groups. Some people say, oh, these Occupy people are just, rabble-rousers and troublemakers and alike, but if it's a veterans group or religious group, well, then their message is good. that's where you'd get into trouble from a First Amendment standpoint. Now, in terms of neutrality and time, place, manner restriction, the restriction need not be the least restrictive, but you have to show that the regulation would permit a substantial governmental interest that would be achieved less effectively without the regulation. So if you waive the insurance requirement, or you let the park be open after 10:30, would you necessarily fail in terms of your governmental interest in the park resource? Probably not. So where you have a narrowly tailored, reasonable time, place, and manner restriction, it can sweep up more speech than is necessary to further the government's legitimate interests. So in other contexts, for example, if you have a governmental restriction that prohibits all nudity, that's generally too broad, because in so doing it sweeps up nudity that would have artistic value, or dealing with young children or alike, where the governmental interest in the public morals and alike could be done with a much better narrowly tailored restriction, where you're targeting pornographic nudity as opposed to just saying, well, all nudity is prohibited. So within this context, therefore, the government may not regulate expression that is more burden than it has to be. But a court won't shoot down the regulation simply because, from their judicial perspective, they think, you could have done a better job, government, some less speech restrictive alternative, as long as there is that necessary connection, narrowly tailored. The courts won't second guess the government if they pass this burden. It can't be too broad, too vague. So it doesn't depend on whether a judge agrees on how the governmental restriction ordinance put together, and that the judge could have done a better idea. It's more of an objective analytical approach. So demonstrating the significance of the governmental interest. Court noted the city here was not required to present detailed evidence. Simply consider, in a narrow tailoring, tight fit requirement, is whether there's a reasonable fit between the governmental interests in protecting the park, having it available for all people, and its impact on the Occupy movement and its free speech content. So we noted earlier, content neutral restriction must also allow alternative ample channels of communication. Even if this channel is less effective than what plaintiffs would prefer. So in the CCNV case, U.S. Supreme Court in 1984, the homeless group says that, well, they're not allowed to live in the mall, they get less people to participate, and it kind of decreases the impact of their message. And the court said, well, you're not entitled to the gold-plated soapbox, the best alternative you can see, as long as it's still reasonable alternative. You could still get your message out, even though it's not in a medium or mode that would be, in your opinion, most effective and most perhaps able to get, on news at 11 kind of thing. So the first challenge we looked at in this case is, what about this extended park hours? Generally, parks were open 6 to 10:30 and they're closed after 10:30. If you're after their 10:30, that's why they were getting cited. Here, Occupy Fort Myers alleged the city's park regulation was unconstitutional on its face because it was an impermissible prior restraint. It targeted their core political speech, which involved occupying park for 24 hours. And furthermore, the most problematic part of the ordinance was there was discretion left in the recreation manager to extend hours to make accommodations for sporting, cultural, or civil activities. So right there, you distinguish, assuming activities have a message, particularly cultural or civil. If you left to the unfettered discretion of an administrative official who gets extended hours and who doesn't, that on its face is unconstitutional. Even though the official may be acting in good faith, the permitting process can't leave that kind of discretion in the individual, who may then be able, even though they don't do so, choose which groups they like or which messages they like. Okay? So here are the specifics of the ordinance being challenged. Except for unusual, unforeseen emergencies, parks are open to the public every day of the year during designated hours. And it mentions the 6 a.m. till 10:30. And here's the point. Such hours shall be deemed extended by the recreation manager as necessary to accommodate athletic, sports events, cultural, or civic events. So, is Occupy being treated differently as its message? Is it in the eye of the beholder, where the Occupy activity could be seen as a necessary accommodation? Who decides? Well, the recreation manager. Problem being that then the recreation manager may get to decide who gets their First Amendment rights and who doesn't. So that's a problem right off the top from a constitutional standpoint. Now, Occupy Fort Myers was not claiming a right to occupy the park, that the park should be kept open 24 hours a day. They weren't challenging that part of the ordinance, but they were challenging, again, this idea such hours can be extended by the recreation manager as necessary. And here's the argument they're making that I mentioned, which is effective, where in other ordinances where it says, well, if in the opinion of the police chief, your activity may pose a threat to the public health, safety, and welfare, he can shut you down. Okay, well, then the police chief gets to decide, well, if you're a veterans group, that's fine. But if you're a bunch of, hippies doing something or, rabble rousers, I'm going to shut you down. So where an ordinance is content-based provision, you have to define what's an athletic, sport event, or cultural event. Argument being, and it's a strong argument, does this ordinance provide unbridled discretion in the recreation manager, even if he or she is acting in good faith, and thus, on its face, this sort of unbridled discretion, unless it could be deemed extended by the recreation manager, that would be a First Amendment violation. In response, the city said it was not content-based because the hours applied to everyone, regardless of the message. That's not the point. The hours could be extended. And they maintain it wasn't content-based, but the fact that it mentions athletic, cultural types of activities, that requires the licensing official to identify what type of messages involved and look into its content. So it's not therefore content neutral. and decide whether or not they get extended hours. So the city maintained the phrase civic activity simply related to its citizens, and therefore effectively means any activities, including Fort Myers protest activities. Now, you could look at it as, since some sports or cultural events would go after 10:30 and you start them earlier, you got a fireworks display or a festival and it's at sundown or like, but it doesn't say that, to say, well, if your event's going to continue past 10:30, then a permit can be provided for that. Here, the court rejected the city's interpretation, saying that it was limited only to those necessary points where, as I mentioned, could be characterized where you go overtime or like on your event. They say, well, that's not what the ordinance says. And they meant something when they mentioned that the rec manager would have the discretion to provide necessary accommodations of only sporting events, cultural events, or civic activities. So, does that necessarily exclude the Occupy movement? It's fatal anyway, because who gets to decide? Apparently, the licensing official has unfettered discretion, and those sorts of arrangements are inherently suspect from a First Amendment perspective. So the court found the plain language of this provision requires the rec manager to examine the nature of the activity. In so doing, it's not content neutral, looking at what's your message and make a decision whether you get to extend park hours or not. So is your message favorable? The Boy Scouts want to have their jamboree and stay 24/7 all night. That's okay. My kid's a Boy Scout. I was a Boy Scout. I was a vet. That's terrific. But these great unwashed, these Occupy people, no, I'm not going to allow them. That's the fear, and why on its face, where the ordinance provides that sort of unfettered discretion for the licensing official, even if they're acting in good faith, more than likely it's unconstitutional. So where you have such a content-based, where the official can look into the nature of the activity and the message, that's where the courts are going to give it strict scrutiny, a real hard look. Here, found that this provision could not withstand, wasn't content neutral. There was no showing of a compelling interest in restricting the extension of park hours to only sporting events, cultural activities, and civic activities. Why were those activities acceptable and perhaps not a threat to the park resource or its continued availability to the public, where the Occupy movement somehow would be? So in the absence of a significant governmental interest, where the courts are looking real hard at this situation where the recreation manager gets to decide, they found, this is too loosey-goosey. You haven't showed a significant governmental interest. It's not narrowly tailored, not enough fit. So they found that at this stage, because we haven't gone to trial, they're simply seeking an injunction in order to make the ordinances unenforceable pending a trial. They said that here, under these facts, it was likely that the ordinance was unconstitutional on its face regarding extended park hours. Now, what about the other issue of the ordinance, typical in many agencies, that would prohibit overnight camping. And here it simply says, well, no person shall live in a park beyond closing hours, in a structure, bring your house trailer, special vehicle, what have you. Here we're in Fort Myers, so, if you can't afford a place to winter down there, you just bring your, truck and live in it or something in a park. That's the sort of activity that they're trying to prohibit. And the question was, perhaps unlike the extended park ordinance we just looked at, what about this overnight camping section? Was it unconstitutionally vague? And an ordinance can be void for vagueness when it fails to provide notice of what is the prohibited activity. And then it allows the police arbitrary discriminatory enforcement authority due to its lack of provision. So such ordinances that are inherently suspect are those, we'll see some evidence of that here, like loitering. Well, if I'm dressed up and I look, like a businessman in a park, I'm just waiting for someone. I'm not loitering. But if I'm a guy that looks like a bum or a homeless individual, then the cop can say, oh, well, you're loitering, and I'll cite you for that. When I was in law school, my criminal law professor mentioned an old 19th century law or ordinance, I think it was Baltimore City ordinance, that was still on the books at the time, and it was called the Rogues and Vagabonds statute. And it basically said if a cop looked at you and thought you looked like a rogue or vagabond, that you didn't belong there, that you could be cited. And clearly that's a type of ordinance that would be leave too much to the imagination, not put you on notice of what'll get you busted, what's criminal. It's too vague, can be used to hassle you. Those kinds of ordinances are unconstitutionally vague. Here, however, the court found that Occupy Fort Myers had failed to show that, a ban on overnight camping, most people get a pretty good idea if you read that ordinance what's going to get you busted. If you're there with your house trailer or your sleeping bag or whatever, and you're there after 10:30, you're camping, you're in violation. So he said, by express term of the ordinance, it's clear to anyone what's prohibited. You can't have tent shacks, other temporary shelters, or moving, house trailers or vans after 10:30, after the park's closed. So persons of ordinary intelligence are not left to guess what's prohibited. Whether I'm indeed loitering or I'm a vagabond or rogue. I mean, that's here, camping is camping. Most people know what that's about. It's not unconstitutionally vague. And the court further acknowledged that Occupy Fort Myers, that a constitutionally protected liberty interest to use their parks just like the general public. Subject, once again, to reasonable time, place, manner restrictions, and there is a significant governmental interest in prohibiting camping, particularly in an area like Fort Myers where you wouldn't want to effectively set up, a low-cost shanty town in your public parks, people camping out. So a liberty interest, they're not saying you can't go into the parks, just that you can't camp there, you can't live there, you can't sleep there. So this particular part of the ordinance passes constitutional muster. And so this idea of liberty claims, restricting, so if you're, some cases you could be cited for misconduct in a park and you're effectively thrown out of the park for 2 weeks And if you come back, you'd be issued a trespass citation by the police. That impinges on your choice, free movement, and liberty, but it doesn't preclude you from going to other parks or somewhere else. Here, they can use the parks just like anyone else, including for their First Amendment activities. They just can't camp there. And as we already saw under the Supreme Court decision from 1984, where camping is mere conduct, not protected by the First Amendment. Now, also in this ordinance, this is sort of like the idea of loitering, this idea of protracted lounging. What is that? When it leaves too much discretion to, the park police or whoever say, well, hey, you're engaging in protracted lounging in the park. Camping is pretty straightforward, but the term protracted lounging, like loitering, may leave too much to the imagination, too much discretion in the licensing official, whether you get busted or not, and therefore may be unconstitutionally vague. So here, Occupy Fort Myer claimed that they had a liberty interest. 14th Amendment protects life, liberty, property. They right to lounge on public benches and places according to their inclination and open air places within the city. So they say, well, we're not camping, we're not living there, we're simply lounging. And here the particular ordinance being challenged prohibited loitering and boisterousness, which again seems somewhat vague to me, sleep or protractedly lounge on seats, benches, loud, boisterous, threatening, abusive, assaulting, or indecent language. And here, this one's okay. Engage in behavior that's disorderly conduct. That's a clear definition in criminal law. But where your such behavior may tend to be a breach of the peace, that's a prior restraint. Well, you look like, a bum or dirt ball. You're kind of yelling and screaming. Even if you're not involved in that, if it's disorderly conduct, clearly you could be cited. But if you look like the person who might tend to do those kinds of things, the kind of people that are involved in the Occupy movement, then here under this ordinance you can be cited. Not for doing it, but the mere tendency. Can you see that would be inherently suspect? And as a result, Occupy Fort Myers argued that this particular provision was also unconstitutionally vague. Where camping wasn't, this one creates once again uncertainty as what kinds of behavior is loitering or boisterousness that'll get you cited, that would be considered offensive and would fall within the sweep of the ordinance and lead to a criminal citation. Now the city said, well, you can't challenge that because we didn't cite any of you for that particular part of the ordinance. But the city had not ruled out enforcement of such an ordinance, so they were under, and again, this is the preliminary stages looking for an injunction pending trial. They feel that, we're under the threat of this particular ordinance as well, getting citations in addition to the 73 we already got. So that's why we would have potential, under the threat of having our rights constitutionally infringed. And the court found, that a portion of this ordinance was unconstitutionally vague because the term protractedly lounge was unclear. Where things like camping or even they said sleeping on benches, you can understand that, but when does lounging become protracted lounging? that leaves too much to the imagination, and when it's left to the imagination of the government official, the cop who's going to cite you, and can be used to harass you depending on whether they like you or not, or the nature of your message, that's the fear we have, and that's why those kinds of vague terms are unconstitutional. So because the ordinance fails to define this crucial term, what is protracted lounging, and it's not clear its intended application, so it could be used to muzzle First Amendment activity, it's unconstitutionally vague on its face. So there's the difference between that and the camping part. So in terms of what's vague here or not, disorderly conduct, breach of the peace, the court acknowledged, those meanings were well established under Florida law and generally criminal law. But this idea of you could be in violation of the ordinance for mere behavior that could tend to be a breach of the peace, that had no established meaning in state law or general criminal law, or unlike something like camping that would be comprehensible, you know what camping is, and therefore you're on notice of what kind of conduct would get you cited or not, that this term behavior tending to breach of public peace was unconstitutionally vague. Accordingly, Federal District Court found that Occupy Fort Myers, therefore, was likely to succeed on this challenge to this provision of the ordinance, which prohibited and which they potentially could be in violation of and be cited for, this idea of protracted lounging and conduct tending towards a breach of the peace. So the court granted a preliminary injunction, in other words, a court order barring enforcement of those sections of the city ordinances that had constitutional problems. We saw the problem with the extended hours provision. Here we see the problem with this extended lounging or conduct tending towards a breach of the peace. On the other hand, the prohibition against just camping, that would probably pass constitutional muster. So to conclude, Federal District Court here said that a preliminary injunction, in other words, a court order barring enforcement of these ordinances, would be granted. Because if it wasn't, Fort Myers could be injured. They would suffer harm due to the deprivation of their constitutional rights to engage in symbolic speech in a public forum in a public park. The court acknowledged even a temporary infringement of First Amendment rights constitutes a serious, substantial injury. And here the city had shown no legitimate interest in enforcing these unconstitutional ordinances. In fact, extended hours and the like had been available. Just leaves too much discretion in the decision of the licensing official, the recreation manager. So the court grants Occupy Fort Myers' request for a preliminary injunction because they found the challenged ordinances here likely violate the First Amendment. And then they would go on to further proceedings to determine whether this injunction would be permanent, that the ordinances would be struck down as unconstitutional and have to be revised and rewritten, or whether indeed they would modify this situation. and whether the controversy still existed. Perhaps Occupy would reach an understanding with the city of Fort Myers, or the demonstration would simply peter out over time, and the parties might decide not to continue that. So that sort of wraps up our discussion here. You see quite a few elements, general principles involving constitutional law, topic of constitutional law in particular, First Amendment rights, and governmental restrictions within the context of a public park forum. I'm Jim Kozlowski. See you next time.